Wild, and I am the CEO and founder of WA Law Group. Our law firm is located in Maryland, just outside of Washington, D.C. I am a first-generation immigrant and have lived in the U.S. for 50 years. Our law firm focuses on all employment-based immigration and work visas. U.S. immigration process is long and complicated. This process becomes even more difficult when the client cannot communicate with the lawyer directly, or the attorney's incompetence leads to an ultimate denial. Having been a partner at other law firms previously and seeing so many clients suffer confusion and anxiety because they did not get the timely updates on their cases, I wanted to establish a different kind of firm where the convenience of our clients and peace of mind takes precedence over our time and fees. At WA Law Group, we strive to answer our clients' phone calls and emails within 24 hours, and I personally stay up past midnight often to answer their emails. Because of this exceptional service, we have been recognized for many years as top 100 immigration lawyer by Top 100 magazine, top 10 attorneys by Attorneys and Practice magazine, and top EB5 lawyer by EB5 Investors magazine, just to name a few. We are particularly known for EB5 cases because we are one of the most experienced EB5 lawyers with 16 years of experience since 2007. We have 100% approval track record, and I have been voted multiple years as top 25 EB5 lawyers in the country. I am proud to say that our source of fund and path of fund tracking for I-5 to 6 petitions are so complete that we rarely get RFEs. In fact, we only had 4 RFEs on source of funds in hundreds of cases we have done since 2007. The most important thing that has changed in the new law that was passed in March of 2022 is the minimum amount of EB5 investment. Instead of $500,000 minimum investment for targeted employment area, TEA, it is now $800,000. Another thing that has been changed is how USCIS will view TEA qualified projects. Although in the past, each state was able to simply write a letter stating that a project is in a TEA zone, the new law requires USCIS to determine the TEA zone. Further, in the past, the regional center was able to use gerrymandering of project area to qualify for 150% unemployment rate, such as in Manhattan, they were able to use Hudson River, where there is no population, to qualify for TEA zone. However, this new law does not allow such manipulation. In addition, there is a new provision of set aside of 20% of the visa numbers for rural area projects and another 10% for infrastructure project. This means there will be less glitzy hotels in Manhattan or Los Angeles or Chicago, but some innovative and useful economic development projects in places like Georgia, Iowa, Vermont, and elsewhere. Finally, there is an integrity measure added to this new law that holds the operators and marketers of regional centers accountable, in that all principals or partners of regional centers, as well as migration agents and brokers, are disclosed and their qualification is notified to USCIS. The finder's fee provided to the migration agents are also disclosed to the USCIS. Although the current I-5 to 6 processing time is more than 58 months, under the new law, a person who is already in the country with a valid non-immigrant visa such as F1, E2, H1B, and L1, etc., will be able to file a I-485 adjustment application concurrently and receive an employment authorization and travel permit while waiting for the I-5 to 6 adjudication. The risk of this concurrent filing, however, is that if I-5 to 6 is denied for any reason, project denial or source of fund denial, the I-485 application is automatically denied and you will have to leave the country. This makes choosing a regional center and an EB-5 lawyer that much more important. You should check on their approval track record and whether they truly have the EB-5 experience instead of just immigration law experience, because EB-5 practice is very specialized. At WA Law Group, EB-5 cases are only handled by 2 top lawyers of the firm and not by the paralegals like in an assembly line fashion. Both partners have combined 30 years of experience in doing EB-5 cases, and we believe that you, our clients, deserve a VIP experience in immigration law as well. Thank you very much.